Will the courts then across the country follow the bail not jail principle? Is trial delay a good ground for bail in a PMLA case? Does the Sisodia case now bail spell hope for Kejriwal and others who have been tangled in jail for a long time? Joining me now at the very top is Abhishek Manu Singhvi. He is, of course, senior counsel, was appearing in the case and senior Congress leader as well. Appreciate your joining us, Dr. Singhvi. Why do you think this judgment is significant? When Justice Gavai says bail not jail, he's only reiterating what we all know. So why is it that it becomes so significant at the moment?
Palkiwala once said, Rajdeep, that the restatement of the obvious is sometimes vital because a lot of people other than this bench seem to have forgotten it. Now, let me answer your questions which you're showing on your screen one by one very quickly in the limited time available. First and foremost, I think this judgment establishes the old basic principle of bail jurisdiction, that it is a robust, commonsensical, not too much of high-flying jurisprudence, not wastage of time. This bench got the matter, it heard the matter in a very short while, it reserved orders and delivered judgment promptly. That is how bails are to be rejected or accepted. That is robust, commonsensical judging. It is not some high jurisprudential flights, which sometimes different benches seem to take.
No, but it's taken 17 months. Sorry to interrupt. It's taken 17 months for the court to get to this point?
No, I am talking about this bench. This matter reached this bench not even 17 days ago or 17, some very short while ago. Now, why is it taken? I'm coming to that point. That's a very important point you're raising. But let me tell you the legal principle which this judgment establishes in sequence to several earlier ones is that 45, which is supposed to be the bugbear, a synonym for not releasing you, special conditions, will be trumped, will be overridden by the larger, higher constitutional guarantees of anti-delay, Articles 20, 21 and 22. Do you see, you need to have, this is only a statutory provision. This cannot excuse or keep you behind for inordinate delay. You must be able to show, of course, in a particular case delay. Here, there is no possible end to the trial in sight. Two earlier, or in fact, three earlier Supreme Court orders have underlined delay. So that's the heart of the principle. But see this judgment as a continuum. I have had the privilege of appearing in three matters where Kejriwal has got bail in PMLA. The principles established are grounds of arrest, reasons to believe. And today, Justice Gavai's order is very significant because in the context of 45, it uses and applies the principle bail, not jail. Now, your question is the core question. Why do we keep coming here? Really speaking, there is a subtext of a lament in the judgment. It is high time the judgment says that trial courts and high courts simply decide it on these broad principles. As I always say, they have nothing to lose except their inhibitions, their hesitations, which are mystical. Today, most of these matters need not even reach the Supreme Court. If they reach the Supreme Court, your 17 months is answered. There is a process, there is a ladder. In this case itself, there was an unfortunate preliminary objection by the government, which said, I should be made to go all the way again back to the bottom because of a certain interpretation of an earlier order of the Supreme Court. In a paragraph, the honorable judges have debunked it rightly, saying that this would be a game of snakes and ladders. So your 17 months are very often spent in this futility of exercises, not keeping in mind the larger paramount paradigm of liberty of the individual.
Yes, but
you welcome this judgment.
Yes, but Dr. Singhvi, the fact is, we are here dealing with the former Deputy Chief Minister of Delhi. What about, there are thousands of under trials in this country who again go through this process of snakes and ladders. I go to a lower court, I'm told lower court won't give me bail, I have to wait till the Supreme Court. So at least Manish Sisodia gets, because of being a Deputy Chief Minister, perhaps gets a benefit that otherwise many others would not, particularly under PMLA.
I'll tell you, in PMLA especially, if you are a supposed VIP, if you are a political figure, the courts are more hesitant. It's the other way around. If you have the anonymity of not being in public life, you are more likely to get bail. That is really the problem. The courts become conscious. The courts become hesitant. There are any number of people who have got bail and should get bail. in the public life sphere, fewer and fewer get it, which is why these court matters land up as so-called high-profile cases in the Supreme Court.
No, so
And
will today's order change anything? Do you believe today's order will change, will make it easier for high-profile detainees, the likes of Arvind Kejriwal and others, to actually get bail? Will that actually happen?
Well, in operational reality, jolly well should. The Supreme Court's orders are supposed to be implemented in letter and spirit. You don't need the Article 141 and 142 of the Constitution to tell us. They have to be. Now, this is the third, fourth time. Remember, there are 3 Kejriwal orders. There is a Sanjay Singh order. There is a Praveer Purakasta order. There are 2 recent judgments on delay in more serious UAPA offences. The point is that this message is driven home. I believe different benches of the Supreme Court have to be more consistent in repeating this message. If the consistency of different benches in the Supreme Court is there, then there is no question that every trial court and every high court in the country must follow this.
But I will ask you this in conclusion, because the trial courts and the high courts across the country are not following it. They seem, as the court itself says, to be too cautious, too unwilling to take a risk in granting bail, which is crazy at the moment.
That is very unfortunate. And the court repeatedly, in this case especially, has rightly underlined it. Absolutely correctly. Now, you know, the Supreme Court, our court system has a limitation that they deal with the case before them. The Supreme Court or the Chief Justice of the Supreme Court, Justice Gavai, can't get up and go to each High Court and say, look, decide this way. They deal with the case before them. Therefore, this message has to be picked up. The problem is, if you don't pick it up, then more time is wasted. I come to the Supreme Court where I get bail, which is why 5 months becomes 10 months, 10 becomes 17 months. Okay. And that is something to be deprecated. As I always say, you have nothing to lose except your inhibition. There is absolutely no reason for fear. The law is clear.
In your view, therefore, is Arvind Kejriwal likely to get bail within a month now?
Now, I have been very free in talking about the Sisodia case because it's over. I'm not going to be that free in talking about a sub judice case, but I can tell you one very striking, unprecedented, unusual thing about the Kejriwal case. It deserves underlining. Kejriwal's case is the only case, perhaps, and certainly one of the few I have done, where I have been successful in getting 3 release/bail orders. One, of course, has been stayed, but 3, 2 by Supreme Court, 1 by trial court. And these are all 3 PMLA release orders. I have yet to come across a case, Rajdeep, where a PMLA release order is followed by a CBI arrest. And CBI, which has got no Section 45, bail is denied. Whereas in the one which has Section 45, you released him 3 times.
Very, very interesting point that you're making there, Dr. Singhvi, and it therefore points out to the fact that many of us believe something in our judicial system will have to give, and will have to ensure greater consistency so that the right to life and liberty under Article 21 is underlined in each and every case in this country. That, to my mind, is perhaps one of the messages that the court, Apex Court, sent today. I appreciate, Dr. Singhvi, you taking the time to join us here today to give us your sense of why you believe this judgment is important once again. I want to play out just now what Manish Sisodia, he came out of jail, Tihar jail, about a couple of hours ago. Listening to what he had to say, he sounded like someone who's now determined to take the fight ahead. Listening to him.
उन्होंने संविधान की ताकत का इस्तेमाल करते हुए तानाशाही के मुंह पर एक तमाचा मारा है। आज मेरा रोम रोम, जब से यह ऑर्डर आया है सुबह से, मेरा रोम रोम बाबा साहब के प्रति ऋणी हो रहा है। एक एक पल मैं समझ नहीं पा रहा हूं कि आज इतने दिनों बाद, इतने वर्षों बाद बाबा साहब के प्रति कर्ज को हम कैसे उतारेंगे। उस वक्त उन्होंने तय कर लिया था कि आने वाले समय में अगर कोई तानाशाही सरकार आके निर्दोष लोगों को जेल में डालेगी तो संविधान इसको बचाएगा। आज मैं बाहर आया हूं तो आपके प्यार की बदौलत, आपके प्यार के साथ साथ भगवान के आशीर्वाद की बदौलत, सच्चाई की ताकत की बदौलत, और सबसे बड़ी चीज जो बाबा साहब ने जो सपना देखा था कि कोई तानाशाही सरकार आएगी तो तानाशाही भरे कानून बना बना के जब नेताओं को, विपक्ष के लोगों को जेल में डालेगी तो इस देश का वो संविधान जो बाबा साहब ने बनाया था उसकी रक्षा करें। मैं आपको अपील दिलाता हूँ, इसी संविधान की ताकत से हमारे प्यारे नेता अरविंद केजरीवाल जी भी बाहर आए। अरविंद केजरीवाल जी चले, जेल के ताले टूटेंगे, जेल के ताले टूटेंगे। ये संविधान की ताकत है कि हमारे प्रिय नेता, इस देश के लोकप्रिय नेता और इस देश के एक बच्चे के लिए शिक्षा पर काम करने वाले नेता अरविंद केजरीवाल जी जल्दी।
Okay, remember, as I said, this judgment has political and legal implications at the moment. Joining me now is Abhimanyu Bhandari, Advocate Supreme Court, the country's leading expert on the prevention, one of the country's leading experts on the Prevention of Money Laundering Act. I'm joined by Biswajit Bhattacharya, former Additional Solicitor General, joins me. He's also tracked the PMLA laws very closely. And Ajay Alok, the BJP spokesperson, is also with us. I appreciate all of you joining us. I want to come to you, Abhimanyu Bhandari. You might have heard Abhishek Manu Singhvi saying, look, this case should become now, what the judge said today, should become a template in all PMLA cases. Bail, not jail. Do you believe that the laws of the PMLA, the statutes of the PMLA make that very difficult because the statute is effectively guilty till proven innocent?
Absolutely, Rajdeep. And that is a fundamental problem with this entire act. This act imposes a maximum sentence of 7 years, but then goes on to say that a person who will go to court to ask for bail will have to satisfy the court that he's actually not convicted, he's not committed the offense. And this is a very high threshold that for any accused to satisfy a court, and therefore large number of cases, many accused are languishing in jail without any possibility of bail. And that's why this judgment, according to me, is a watershed in the jurisprudence of bail in PMLA cases and generally in economic offences cases. That is because the court says that regardless of what the statute says, regardless of the harsh conditions that such statutes impose, the fundamental principle is that courts should be mindful of the fact that if the trial is going to take time, then one needs to consider that an accused has a fundamental right to speedy trial. And therefore, that is the overarching principle that every constitutional court or every trial court should keep in mind and see whether trial can be completed in a short time or not. And if you see that there are a large number of witnesses, number of documents that the court has to go through, then the court should not get constrained or shackled by the wordings of the statute and the conditions, the rigorous conditions, but should go ahead and grant bail because every accused has a fundamental right to a speedy trial. And this is a statement which is not repetitive. I agree with what Dr. Singhvi says, but please know that in the PMLA jurisprudence, we needed this judgment badly to assert that this is a criteria which the court has to consider and not just get bogged down by the twin conditions of the PMLA Act. The problem is that the courts, the trial courts and the high court are so bogged down by the wordings of the rigorous conditions that a lot of time is spent in understanding whether the accused has committed the offense or not at the bail stage. And the focus is not whether the trial can be completed in a short period of time. So I think this is a watershed in the jurisprudence of bail.
Is it that the courts are bogged down, Biswajit Bhattacharya, by the nature of PMLA, or are they too scared? When it comes to high-profile cases, no judge of the trial court or the high court wants to be seen to be granting bail out of a sense of fear. The court, Supreme Court today, almost alluded to that. But is that the problem, that there is a fear factor out there?
Absolutely, Rajdeep. Today's judgment very categorically records that the judges of the subordinate court and high court, they played safe. And so today, in fact, it's a very solemn message that this judgment has given to the entire judiciary across the length and breadth of the country, cutting across subordinate judiciary and the high court. Now they better follow the judgment. Otherwise, a day will come under Article 141, 142, 144, the Supreme Court may have to strike and strike hard.
No, you really believe that the courts will wake up today?
Yes, courts have no option but to wake up, you see, because just last week, when one honorable judge of Punjab and Haryana High Court had crossed the limit, then a 5-judge constitution bench sat, and then it rose to the occasion by refraining from exercising its powers. The court gave the message that power is not ability to strike, but ability to refrain from striking. So this judgment for the first time on a historic day, today 9th August, I think today is the Quit India movement date. So I think the refreshment, it's a very refreshing order to two of the, in fact, this is a very fine judgment given by the bench. And Article 21, the right to speedy trial, which we have been reading from the student days, that has been upheld. And for 17 months, the trial has not even commenced. What a shame.
But the fact is, so who's going to, the fact is, of course, you make a strong point, and people will ask who will give Manish Sisodia, therefore, back his 17 months. The trial has also not commenced in the case. And Ajay Alok, therefore, the charge which is being made is that the PMLA has been weaponized. 90% of the politicians, 95% of the politicians who've been charged under PMLA are from the opposition. The conviction rate in those cases remain low. And most of the cases have not been brought to trial for months and years on end. The process has become the punishment, and the government, according to the opposition, has used it to target opposition leaders. Manish Sisodia being the latest case. Your response?
First of all, if PMLA is so much draconian, and Supreme Court would have thought so, then why not Supreme Court took the whole PMLA Act into revision? They should have scrapped it. Don't twist that matter. He has just got a bail which is fundamental right of every citizen. And Supreme Court very clearly considers him as Mr. Sisodia as a considered criminal. They never went into the merit of the case. They said that keeping a person for 17 months without the trial process has begun is not a criteria, so bail should be given. That's its sacrosanct right.
Yes, but that's the process is the punishment. Dr. Alok, that's precisely it. You keep someone in jail for 17 months without the trial commencing. That's where the process is the punishment in this country at the moment.
And by Rajdeep, by you saying so, that the lower courts are scared, that means you are not following the authority of the lower trial courts and the high courts. They're all scared. I mean, this is not a kind of a statement to be made by a senior journalist like you.
No, 1 minute. Have you
That's
heard?
What I'm saying.
That's
what I'm saying.
What I'm saying. 1 minute, Mr. Alok. I'm only telling you the hint given by Justice Gavai.
Let me complete.
Please go ahead. Please go ahead.
Yes. First of all, Manish Sisodia has not been exonerated. He has just been given bail. There's an ample evidence. And today, Supreme Court never went into the merit of the case. Had Supreme Court been so convinced that he's real saint, why like a considered criminal, he has been released onto all those kinds of...
why is the trial not commenced? Why is the trial not commenced? Why is the trial not commenced, sir? 17 months. Are we saying that now people will be kept in jail while the ED says we are continuing to investigate? Is that not, in a way, against my right to life and liberty?
The trial has not commenced because on 3rd July, Mr. Sisodia's lawyer, they demanded for the papers, which they have all right to do so. It was supposed to be given by 3rd July, and that process of investigation cannot be completed in 6 to 8 months. It was very clearly stated in front of the Supreme Court. And there are more than 1,000 documents. There are more than 400 witnesses which needs to be present in front of the court. And the Supreme Court clearly said that it's not possible that in a limited frame of time you can examine all these evidences in the court. So it's going to take a long time. So let's give him a bail. Why are you making Sisodia a hero? Okay. Lalu Yadav also got bail in Forest Camp. Was he a hero? Later on he got convicted. Today also he's on bail on health grounds. Does he become hero? If in this country, if anybody gets bail on any offense, does he become hero?
Okay.
I mean, why so Lord worshipping about Sisodia?
Okay,
and why is the draconian law by the center? Lalu Yadav was convicted. When Lalu Yadav was convicted, was BJP in power? When Lalu Yadav was first charged with the CBI, it was BJP in power. The ample incidents. Don't raise your fingers at the sincerity of the trial courts or the high courts.
Okay.
Then let Supreme Court decide every case. What's the need for high court?
Okay,
and what is the need for the trial court?
That's a good point that I want to take to Abhimanyu Bhandari. Here's the BJP spokesperson on the show saying, don't treat the high courts and trial courts as simply rubber stamps that they will not grant bail. The truth of the matter is Manish Sisodia's merits of the case have not been decided. It's purely a procedural argument that has been made, and that's how the BJP is seeing this. It's not the weaponization of PMLA, just the process of the law.
Yes, but Rajdeep, when a person is asking for bail, he should not be made to justify the merits of the case at all. Merits of the case will be dealt with at the final hearing after evidence has been led by all the parties. Don't forget, today in our country, there are 5,297 registered PMLA cases in the last 10 years and only 40 convictions have happened. Does this mean that every accused person should languish in jail and wait for his day to come till the trial is over? Certainly not. Bail is not a forum to decide the merits of the case. What is important in our country is that we now follow a pattern where bail becomes the rule. And these new conditions, you see what has happened, Rajdeep, that since we've recently in the last 10 years, we've seen that a number of these statute books have started coming out with conditions which are very similar to stringent Terrorism Act conditions, that a court has to be satisfied that the person has not committed the offense and then only grant bail. And I think it is time our jurisprudence moves on and frowns upon such conditions. Don't forget that
why does the trial, if you can explain to our viewers, Abhimanyu, why does the trial take so long? Why has it taken 17 months and the matter doesn't reach trial? The original arrests were made in September 2022.
Well, very well. First, ED itself did not complete the investigation for so many months. ED itself has taken time and again to complete the investigation, and they filed 8 charge sheets. So therefore, they will take time to complete investigation. Until their investigation is not complete, trial can't begin. Second, look at this case. In this case itself, there are 439 witnesses. So each of those witnesses have to be examined, and therefore this is going to be a time-taking procedure. Also, there are 60,000 pages of documents which one has to go through. Our courts are anyways, there is a backlog of huge amounts of cases. So to finish a criminal trial of this magnitude in a speedy manner is a challenge.
Right.
Plus, investigating agencies do take time to complete investigation. Ask ED how much time they took in this case to complete investigation. So it's not like that the accused doesn't want the case to proceed. But Rajdeep, forget all this. I'm on a very basic principle of law. Why should we keep a person behind bar if he's facing a trial and we feel that the person is not going to run away from the course of justice? The question we need to ask is Manish Sisodia going to run away from the country and not face trial? Certainly not.
Okay.
He's a man with deep in the society. People like them should be granted bail.
Of course, earlier the trial court judgment, so the ED said before the trial court the possibility of his interfering with documents. But yes, Ajay Alok, you're raising your finger. Please go ahead.
First of all, I'd like to remind him that the Delhi High Court very categorically said that since this person, Manish Sisodia, is handling 18 departments and virtually in hand in gloves with, it seems that he's hand in gloves with all the mafias. So it's not wise and prudent to give him bail. That's why Delhi High Court rejected his bail. That was the wordings of Delhi High Court. Now, second thing, we are not discussing about judicial reforms or judicial jurisprudence and how we should reform it. Bail cannot be the rule. If that is going to be the rule, what about the terrorism charges? What about Umar Khalid? What about the sedition charges? Bail cannot be the rule. If the court is not satisfied that you are not going to tamper with the evidences. Today, Supreme Court has also said that most of the evidences have been collected. So we don't think that he's going to tamper with the evidence anymore because all the evidences have been collected and it is submitted in the due court. Additional supplementary charge sheets have been filed. So there is no reason to keep him prolonging.
Okay.
So let's not mix two things.
No.
What you're talking is of judicial reform, that bail should be the law. It cannot be the law, my dear friend.
You're
if
saying
this
bail?
Is going to happen,
No, 1 minute. Let the lawyer, Vishwajit Bhattacharya, here you've got the politician saying bail cannot be the rule in this country. He's saying, what about Omar Khalid? He's raised Omar Khalid, who has spent 4 years without any conviction. He's in jail.
He may raise individual cases. I am not concerned about individual cases. Bail is the rule, jail is the exception, and that has been very emphatically reiterated today. And my learned friend
so why should an Umar Khalid also not get the same benefit then tomorrow?
No, Umar Khalid, everybody should get the same benefit depending on the conditions of bail. Based on each fact and circumstances, bail is the rule. Okay. Now, today, the stage has come. This cannot be superseded anymore. And, Rajiv, I was just going to say that individual and cases of merit, for a bail application, merit is hardly considered ever. I mean, here the trend has been set in the lower courts and high courts that while hearing a bail application, arguments go on and on and on. That's not the intention of either the legislation or the case laws.
Okay.
So my final submission before your distinguished audience is this is a very refreshing judgment. I am not concerned about individual Umair Khalid or Manish Sisodia. If somebody has committed a wrong, hang him. But hang him after a due process. But the process which has been followed in our country has been set right and corrected by a very strong, refreshing message, by a historic judgment of the Supreme Court. And this judgment must be read by every judicial officer in the country.
I'm running out of time.
Classic historic judgment.
I'm running out of time. I'll give Ajay Alok before, otherwise he will say I didn't give him sufficient time. You have 30 seconds. Your time starts now.
I'll just put one thing in front, that every case, it's not a matter of individual case, but in general, bail cannot be a law and jail should be an exception. If that is the case, in this country, we have seen Kasab, who was arrested in 2009.
But now are we going to compare, Ajay Alok, we are comparing Kasab now with Sisodia. We are going to compare Kasab with Sisodia.
No, he should have also got the bail, if that is the logic.
No, that's not the logic.
Got the bail. Why he was not put on bail?
No, you cannot compare Mr. Dr. Ajay Alok.
You cannot justify that you have a right to get bail in every case. Even the trial has not started. This is not an argument at all.
Okay. I'm going to leave it there. I've heard all three sides and it's good and reassuring to hear three different perspectives. Thank you all very much for joining us. Abhimanyu Bhandari, Vishwajit Bhattacharya, Ajay Alok. Bail not jail. Or is it jail not bail? You decide. The courts certainly have sent out a strong message.